All right, so we're diving into something pretty familiar to you, those 30-day eviction notices in California. As a tenant eviction attorney, I'm sure you deal with these all the time. But we're going to try to go a little deeper with it, uncover some things, some interesting points that maybe you can use in your practice at the Martinez Law Center.
Yeah, I think the interesting thing about 30-day notices is that a lot of people, they understand that it's like, a step towards getting evicted. But they don't really understand, the intricacies of it. It's not actually the eviction itself. It's just a legal notice that basically says, hey, we're thinking of potentially ending your tenancy, so you got to be out in 30 days. It's month-to-month tenancy.
Exactly, yeah. And for you, that means really understanding how these notices can be used, when they're appropriate, and more importantly, when they might not be.
Right.
Because that's where things get a little dicey.
Especially in California, which, we have a lot of laws that try to protect both landlords and tenants.
Okay, so let's get into the details. One thing that I found really interesting was that the 30-day notice is really standard when a tenant's been living on a property for less than a year. It's for those month-to-month tenancies. But why is that? What's the reasoning behind that specific time frame?
It's kind of like a balance. Landlords have to have some kind of flexibility, right, when it comes to managing their properties. But you also have to give tenants, some stability. So, imagine if landlords could just be like, hey, you got to be out next week.
Right, yeah.
That would be very disruptive. But then on the other hand, if you make it too long, it kind of ties the hands of landlords unnecessarily.
That makes sense. It's like finding that middle ground to protect both sides.
Yeah.
Now, one thing that, honestly, I raised an eyebrow at when I was reading about it was this concept of no-fault evictions.
No fault, right.
Yeah, no fault.
So this is where the landlord doesn't actually have to have a reason to end the tenancy.
So a tenant could be paying their rent on time, not breaking any rules, and still get one of these notices.
Yeah, there are certain situations where that happens. Like, for example, one of our sources talks about when the landlord maybe wants to move into the property themselves, or like a family member wants to move in. Those would be no-fault evictions.
Wow, that's so interesting how there are these no-fault situations. You would think there'd have to be some kind of, a violation or some problem.
Right. It seems a little paradoxical. And in some areas, like places with rent control or other protections for tenants, it might not be allowed or it might have certain conditions.
And that brings us to the other side, just cause evictions, where it seems a bit more straightforward.
Right. So just cause is when a landlord actually has to have a valid legal reason to end that tenancy.
And looking at the sources, we saw some familiar reasons. Not paying rent, breaking the lease, damaging the property. Basically, the tenant has done something that gives the landlord grounds to evict them.
Yeah, exactly. And this is really where your expertise comes in as an attorney, especially when you're representing tenants.
Right.
You really have to understand what constitutes just cause and whether the landlord followed the right procedures and has the right documentation.
It seems like it really comes down to the details.
Absolutely. Even if it seems like a clear just cause situation, there might be something the landlord missed that could make the eviction invalid.
So, if a landlord's claiming just cause because of noise complaints, you'd want to dig deeper.
Exactly. Are the complaints documented? Did the landlord give proper warnings to the tenant? Did they try other ways to solve the problem before resorting to a 30-day notice? These are all really important questions to consider.
Because if they didn't do all that, the notice might not be valid in court.
Exactly. That's where knowing California tenant law comes in, right? You can use that knowledge to potentially help your clients avoid eviction, even when a landlord thinks they have a clam dunk case.
Okay, so we've talked about when these notices are used and the different types, no fault versus just cause. But let's say a landlord decides to send out a 30-day notice. What makes it official and valid in California? What are the things you, as an attorney, absolutely have to look out for?
There are several things that are crucial. If even one of these is missing, the notice might not be valid. For example, it has to be in writing. No verbal agreements or casual notes will do.
Right, it has to be a formal document.
Yeah. And of course, it has to clearly identify the property. The full address has to be there, with no room for confusion.
Makes sense. Now, what about delivery? Is there a specific way they have to give this notice to the tenant?
Absolutely. California law is really specific about that. You can't just slip it under the door or leave it on the doorstep.
Okay.
Usually it's delivered personally or sent by certified mail. That way the tenant actually gets it and the landlord has proof.
So it's not just what's the notice, but also how it gets to the tenant.
Right. And within the notice itself, the tenant's full legal name has to be there, along with a clear statement that the tenancy is ending.
And I saw in the source material that it should also include the exact date they need to be out and information about getting their stuff back.
Yeah. Tenants need to know what they're supposed to do even when the tenancy is ending.
Makes sense. And of course, the landlord has to sign and date it, right?
Of course. The signature and date are super important for making it official and establishing a timeline.
Okay, so we've covered a lot. When these 30-day notices are used, no fault versus just cause, and what makes them legally solid. But let's be real. Sometimes, even with a valid 30-day notice, the tenant doesn't move out. What happens then?
Well, that's where things can get tricky. And that's where your role as an advocate for tenants becomes even more important. So yeah, a 30-day notice is a pretty serious thing, and it has to be done right for it to be valid.
Right, absolutely. But what about when a tenant doesn't leave after they get a valid 30-day notice? What happens then? I mean, sometimes people can't find a new place in time. Or maybe they think the eviction isn't fair and they want to fight it.
That's when it can turn into a legal battle. And that's when it's really important for you and your clients at the Martinez Law Center to understand the unlawful detainer process in California.
Unlawful detainer. That sounds pretty serious. Is that like the formal eviction process?
Yeah, pretty much. It's a specific process in court that deals with situations where a tenant is living somewhere they're not supposed to be after their lease or rental agreement has ended. And it's important to remember that it's a separate thing from the 30-day notice.
So the 30-day notice is kind of like a warning shot. And if that doesn't work, then the landlord can go to court and start this unlawful detainer lawsuit.
Exactly. And unlawful detainer cases can be pretty complicated. There are specific procedures and timelines and different ways to defend yourself. It's not something you want to try to handle on your own.
Yeah, I bet. It sounds like having a good lawyer is super important in these cases, especially since they can move through the courts pretty quickly.
Absolutely. Tenants need someone who knows the law inside and out, who can look at their specific situation, and who can fight for them in court. That's where lawyers like the ones at the Martinez Law Center can really make a difference.
Now, let's talk about what could happen to a tenant if they lose an unlawful detainer case. What's the worst that could happen?
Well, the biggest thing is that they could get evicted. That means they'd have to leave the property, and they might not have much time to do it.
And I imagine having an eviction on your record would make it really hard to find a new place to live.
Yeah, it can be a huge problem. A lot of landlords do background checks, and if they see an eviction, they might not want to rent to you. That's why it's so important for tenants to understand how serious this is and to have a lawyer to help them protect themselves.
So it's not just about losing their home now. It's about maybe not being able to find a place to live in the future. That's a lot to deal with.
It is, and that's why the work that you do at the Martinez Law Center is so important. You're helping tenants understand their rights and navigate this whole process, which can be really confusing.
You know, we've been focusing a lot on the landlord's perspective, but it's also really important to remember that tenants have rights too.
Right. It's easy to forget that sometimes.
Yeah. What are some of the key things that tenants should know about their rights when they get a 30-day notice?
Well, one of the most important things is that tenants don't just have to accept a 30-day notice. They have the right to challenge it if they think it's wrong or if the landlord didn't do things the right way.
So they have options. They don't just have to pack their bags and leave.
Exactly. If they get a just cause notice, but they think the reason is bogus or that the landlord didn't follow the rules, they can fight back.
How would a tenant usually go about challenging a notice?
Well, sometimes they can try talking to the landlord directly to see if they can work things out. But if that doesn't work, getting a lawyer is the best thing to do.
And that's where the Martinez Law Center comes in, right? Helping people figure out their rights and representing them in court if they need to.
Exactly. We can help them figure out if the notice is even valid and what their options are. Sometimes just having a lawyer send a letter to the landlord is enough to make them back down. But if the case goes to court, it's really important to have an experienced lawyer on your side.
What about during the actual court process for an unlawful detainer case? Do tenants have any rights once that's started?
Oh, absolutely. California law makes sure that tenants get treated fairly throughout the whole process. They have the right to go to the hearings, to present evidence, and to tell their side of the story. It's not like they just have to accept whatever the landlord or the court says.
So due process is really important here.
It is. And tenants should also know about retaliatory eviction. That's where a landlord tries to evict a tenant because the tenant was trying to stand up for their rights.
That sounds awful. What's an example of that?
Well, Let's say a tenant complains to the city about dangerous conditions in their apartment, and then the landlord gives them a 30-day notice. That could be seen as retaliation.
Or if they ask for a repair, like a leaky faucet, and then all of a sudden they get a notice. That seems suspicious.
Exactly. The law is trying to protect tenants from being punished for speaking up or asking for repairs that they're entitled to. Landlords can't use 30-day notices or evictions to silence tenants who are trying to exercise their rights.
So knowing your rights is really important, both for landlords and tenants.
I agree. And having resources like the Martinez Law Center, where tenants can get good information and legal advice, is so valuable.
You know, it's really kind of crazy how much people don't know about evictions. Like, a lot of tenants come to us at the Martinez Law Center and they're just totally lost. They're like, what are my rights? They don't even know where to start.
Yeah, I can imagine. It's a really stressful thing to go through, and there's a lot of misinformation out there that can make it even worse.
Yeah, for sure. So let's talk about some of those misconceptions. From your experience working with tenants, what are some of the most common ones you've come across?
Well, one of the biggest ones is that once you get a 30-day notice, that's it. You're getting evicted no matter what. A lot of tenants think they just have to pack up and leave. They don't realize they have options, they have rights.
Yeah, they kind of see it as a done deal.
Exactly. And it's not true at all. Like we've talked about, tenants can challenge a 30-day notice, especially if they think it's bogus or if the landlord messed up the process. There's always a chance to fight back.
Another one I've heard is that you can only get a 30-day notice for really serious stuff.
Right.
Like not paying rent or trashing the place. It's like they don't get the whole no-fault thing.
Right. People think you have to do something really bad to get evicted. But as we know, in California, landlords can give you a 30-day notice for no-fault reasons, too, like if they want to move in themselves or a family member needs the place.
Which must be so frustrating for tenants who've been doing everything right, paying their rent on time and all that.
Oh, absolutely. It can feel really unfair. And that's why it's so important for tenants to know what the law says. Knowing your rights is the first step to protecting yourself.
And speaking of knowing their rights, sometimes the biggest problem is just knowing where to get help.
Yeah, that's true. Dealing with the legal system can be scary, especially when it's about your home. A lot of tenants feel lost and overwhelmed. They don't know who to trust or how to find the right information.
And that's where places like the Martinez Law Center are so important. You guys are not only providing legal expertise, but also giving people hope and support when they need it most.
Yeah, we try to be a safe space for tenants where they can feel heard and understood. We want to help them through this tough process and make sure their rights are protected.
It's a really amazing work you do, making a real difference in people's lives. Well, I think we've covered a lot about 30-day eviction notices in California. Any final thoughts for our listeners, especially those who might be going through this right now?
If you get a 30-day notice, don't freak out. First, take a deep breath. Get all your paperwork together, like your lease and any communication you have with your landlord. And most importantly, talk to a tenant lawyer as soon as possible. Places like the Martinez Law Center offer free consultations so you can get some guidance. Remember, you don't have to go through this alone.
That's great advice. Knowing your rights and having a good lawyer on your side can make a huge difference. Well, that wraps up our deep dive into 30-day eviction notices in California. Hopefully this was helpful and informative. And remember, if you're ever facing eviction, reach out to the Martinez Law Center. They're there to help you. Thanks for joining us on the deep dive.
Call now 714-442-9741. Thank you.